Greetings all. This is part 2 of chapter 3, so lecture 2 of chapter 3. And we're going to go right into, I believe it was learning objective 3 here. So that talks about the dual court system. We've already talked about this a little bit in the first lecture, and hopefully you read about it. But obviously the legal system within the United States has two parallel court structures. One's a federal system, one's a state system. I've already talked about, in general, which types of cases go where, but once a plaintiff files a case in one of these two systems, typically the case remains in that system throughout the appeals process. Obviously, in the first lecture, we talked a little bit about where there's concurrent jurisdiction, in other words, federal and state jurisdiction over the matter, over the subject matter, I should say. Then occasionally you'll have it start at or be filed at the state court level and then be moved to the federal system. But that would be only in those concurrent jurisdiction situations. The only exception other than that to this rule would occur if one party or the other of a lawsuit appeals whatever decision all the way up to the state Supreme Court, and then once there is still unhappy with the decision and makes an appeal to the U.S. Supreme Court. So that would be the only exception to, once you've started and the trial court has heard the whole case, rendered a judgment, then, if you don't like the judgment, then it gets appealed, and it gets appealed all the way to the, assuming we started in state court, all the way up to the state Supreme Court. Then we have one last resort option of appealing to the U.S. Supreme Court, which obviously is within the federal system. So this is what the basic outline of the federal court system looks like. The power that allows the federal court system to act comes from Article 3, Section 2 of the U.S. Constitution and consists of these three main levels. Trial courts, which in federal court are called district courts, intermediate appellate courts, which for the federal system would be called appellate courts, or district courts. I'm sorry, not district courts, but I'm drawing a blank on the word here. It'll come back to me, but I'll move on from that. But lastly, you have the obviously within the federal system, your court of last resort is the United States Supreme Court. I believe in this chapter, in this portion of your book, it talks about how rare and unlikely it is, even if you want to appeal to the state Supreme Court, that they will actually hear your appeal. Now, depending on the system, whether state or federal, some state systems do not even guarantee you one level of appeal, but most do. And I believe there are a number of state systems that will allow you to appeal, but don't necessarily guarantee you the option of appealing to the state Supreme Court. And obviously, if you read this chapter in the book, you know that even if you file to appeal to the United States Supreme Court, I think you have, I believe, like 3 or 4% chance once you file your appeal that they will actually agree to hear the case at that level. So we already talked about the state court system a little bit. Let's see. Well, we haven't talked a lot about just what appellate courts do. I can't remember if, let's see, I don't think we go into any more depth in this slideshow, so I'll just talk about it here a little bit. But at the court of original jurisdiction or the trial court, that's where all the facts come out. So the facts are argued at that point, and a decision is made upon which facts the court believes to be the facts of the case. So that's set out at the trial court level. Then, if it gets appealed at that level, then basically what you are saying is, hey, we established the facts here at the trial court level, but the judge made some type of error in applying the law to these facts. And because of that error, the outcome came out wrong. So that's why appellate court levels don't really hear cases. They review briefs, and occasionally they will allow some attorney explanations, or they may call for some other party to explain something there. But for the most part, they look at the paperwork and the transcripts of the trial court's decision, and they determine whether the judge or the court in general made an error in applying a law a certain way. And if they did, they may say, okay, based on the facts that the trial court set out, the judge applied the law in this way, it should have been applied in another way, and so we're going to reverse the decision. A lot of times what happens is, excuse me, the appellate court will say, hey, the judge made a mistake. Because of that mistake, the facts didn't get hashed out correctly. And this may be like a judge not allowing certain elements of testimony or something like that. So at that point, the decision will be reversed, or basically nullified, and the case will be sent back to the trial court or remanded, so that the trial court can then apply what the appellate court said is the proper way to apply the law, and at that point hash out the facts better and then make a decision. It may be the same decision that they ultimately end up making, but the error will be cured that they made originally. Alright, so there are 3 threshold requirements to have any case go to court. So before a case makes it to court, these threshold requirements have to be met. That way, basically, you're ensuring that the courts hear only cases that genuinely require their adjudication. So these requirements are standing, case or controversy, and ripeness. So in order to initiate or begin litigation, the plaintiff must have standing to sue. There must be a justiciable controversy, and the case must be ripe for trial. What does that mean? Basically means standing, I think we talked about a little bit already, but basically the plaintiff themselves will have to, if we didn't talk about this, I know your book goes into greater detail, but the plaintiff, him or herself, must be the ones that were actually harmed or are imminently in danger of harm by whatever action is being sued about. So if my brother got hit by a car and is in the hospital, I can't go and sue on my brother's behalf, right? Because I'm not the one that got hit by a car. My brother has to be the one that brings the action. And obviously, sometimes, for instance, if my brother got killed in the car accident, there may be a different lawsuit, but that would be a lawsuit saying that I was harmed because my brother was killed. It wouldn't be me just saying, hey, my brother was harmed in this accident, and now I want to sue because of that. So that would be standing. Whether there's an actual controversy just means, hey, did this happen? Is this imminently happening right now? Or is this just us saying, hey, what about hypothetically, if this happens in the future, how would you rule? So the hypothetical case should not be heard. Only if there is actually something that can be determined that has happened or is imminently happening at the moment, those types of cases or controversies are what we want to hear, because those are ones where we can actually provide some remedy or relief. We're not just saying hypothetically. It's called an advisory opinion, where we say, hey, if this happens in the future, this will be the result. That's considered a waste of judicial resources. And then ripeness, and that just basically means that this concept or whatever it is we're talking about needs to have some remedy that will change it when the case is being heard. So generally it means if the plaintiff is suing to have something done, or to have someone not be able to do something, and the defendant has already agreed not to do that thing before the case even was filed, then that would lack ripeness. And there's some other examples in your book that you can take a look at as well. So I won't talk about these in great detail, but these are the steps in the pre-trial stage of civil litigation. Your book obviously goes into much more detail, but you've got informal negotiations, pleadings, service of process, defendant's response, pretrial motions, discovery, and pretrial conference. Then in the actual trial, you've got jury selection, or voir dire, if you're trying to pronounce it in Latin, or voir dire if you're just trying to read it like it would seem in English. Opening statements, examination of witnesses and presentation of evidence, closing arguments, and jury instructions. I think your book mentions that in a couple states the jury instructions actually comes before the closing arguments. But for all of these steps in civil litigation, very important that you read what's in the book. It does a good job of describing each of these various steps. In the post-trial motions, you've got motion for judgment in accordance with verdict, and that basically means, hey, a verdict was rendered, we'd like to make a motion for that judgment to occur after the verdict was rendered. So that's typically what happens. Then you've got a motion for a judgment notwithstanding verdict, which basically means no reasonable jury could have come to the decision that these people came to based on the facts that were accepted in this case. So we're making a motion for a different judgment than what the verdict of the jury was, because we're saying no reasonable people could have come to that conclusion. And then you've got a motion for a new trial for various reasons. Again, much more depth in the reading. Then in the procedure, if you're going to appeal, either or both parties can appeal a judge's decision using a post-trial motion or on his or her final judgment. Sometimes both parties appeal the same decision. So an example of that might be a jury awarded the plaintiff $10,000 in damages. The plaintiff and the defendant may both appeal in that case the amount of the judgment. Appellate courts generally reverse about 1 in 10 of every trial court decisions. So what that means is just because you're appealing does not mean you're likely to win your appeal. So to be eligible for appeal, the losing party must argue that there was some type of prejudicial error of law being applied to the facts that occurred during the trial. Prejudicial error of law is some type of mistake that's so significant that it is likely that it may have affected the outcome of the case. To appeal a case, the attorney for the appealing party, which is called the appellant, files a notice of appeal with the clerk of the trial court within a certain prescribed time, and that will vary state to state and at the federal level. The appellant then files a brief, which is basically just a written argument with the court. The appeals court then usually allows the attorneys to present, or oftentimes anyways, allows the attorneys to present some type of oral arguments to the appellate court. Again, as I mentioned, the appellate court doesn't generally hear testimony of witnesses and all that stuff. The court considers the arguments, reviews the record of the case, and then generally renders a decision. So, when rendering a decision, these are the 4 options that will occur: affirmation, modification, reversal, or remand. So affirmation just means, hey, we agree with what the trial court said. Modification means, hey, we're just changing something slightly, but in general, the trial court decision stands. Reversal means we're saying, no, that's wrong, and we're going to reverse the judgment of the trial court. Now, obviously, in that case, it would have to be whatever error of law is being claimed would have to be something that determined the final outcome of the case. And then remanding to the trial court is basically saying, hey, we believe there was this error, and because of that error, maybe not all of the facts came out correctly, so we're going to send this back to the trial court level to be at least retried in whatever was the mistake, whatever portion was mistaken. Go through that trial again and not make the same mistake twice, thereby having no errors of law and then reaching a new or maybe the same verdict as what was originally in there. Alright, for our hypothetical cases here, since I'm kind of running long on time on these, I like to keep them below 15 minutes. I'll just let you read hypothetical case 3 here and hypothetical case 4 on the next slide. Again, as I said, where there's questions, try to look at both sides of the questions, apply what you know or what you think, and just give it some thought, maybe jot down a few notes. So here's hypothetical case 3, and here's hypothetical case 4, and obviously you can pause if you need more time to take a look at these.